I'd like to call up amendment number 133 and would ask consent to lay aside the pending amendment.
Without objection. The clerk will report.
The senator from California, Mrs. Feinstein, for herself and others, proposes an amendment numbered 133.
Thank you very much. I appreciate that. I ask unanimous consent that at the conclusion of my remarks, my amendment be set aside and that the Senate return to the previously pending business.
Without objection.
Thank you very much, Mr. President. I rise today to offer an amendment to strike the first-to-file provisions of this bill. I'm joined in this effort by my co-sponsors, Senator Risch, Majority Leader Reed, and Senators Crapo and Boxer. I also ask unanimous consent that Senator Ensign be added as a co-sponsor of the amendment.
Without objection.
Thank you. I know that the bill has contained these provisions for some time now, and I acknowledge that I have voted for different versions of it that contain these provisions. But I've heard more and more in the past 2 years from small inventors, startup companies, small businesses, venture capitalists, and yes, even large companies from all around our country, but especially in my state of California, that this proposed transition from our first-to-invent system to a first-to-file system would be severely harmful to innovation and especially burdensome on small inventors, startups, and small businesses. And I have become convinced that it's the wrong thing to do. For the benefit of my colleagues who have not been so embroiled in this rather technical issue, let me provide a little background. For over a century, our country has awarded patents to the first inventor to come up with an idea, even if somebody else beat them to the patent office. A first-to-invent system. And we have done very well under the first-to-invent system. This bill would change that so that the first person to file an application to a patent for a particular invention would be entitled to that patent, even if another person actually created the invention first. And this is what's known as the first-to-file system. Now, the argument for first-to-file is made for transitioning, is that the rest of the world follows first-to-file. And this will harmonize our system with theirs. This is really supported by big companies who have already made it, who have an international presence. Therefore, I understand their support for first-to-file. But under first-to-invent, we have been the world's leader in innovation, and the first-to-file countries have been playing catch-up with our technological advances. So without all due respect, I wouldn't trade America's record of innovation for that of virtually any other country, or certainly any first-to-file country. The genius of America is inventions in small garages and labs, in great ideas that come from inspiration and perspiration in such settings and then take off. So many of America's leading companies, Hewlett-Packard, Apple, Google, even AT&T arising from Alexander Graham Bell's lab, for example, started in such settings and grew spectacularly, creating jobs for millions of Americans and lifting up our economy and standard of living. A coalition of affected small business groups, including the National Small Business Association and others, recently said, and I quote, that first-to-file disrupts the unique American startup ecosystem that has led to America's standing as the global innovation leader, end quote. It's critical, I believe, that we continue to protect and nurture this culture of innovation. And preserving the first-to-invent system that has helped foster it is essential to do this. Moreover, this bill would not actually harmonize our patent priority system with that of the rest of the world. Many first-to-file countries allow more extensive use of prior art to defeat a patent application and provide for greater prior user rights than this bill would provide. And Europe does not provide even the limited one-year publication grace period that this bill does. An important part of this debate are the changes that the bill makes to the so-called grace period that inventors have under United States current law. Presently, a person's right to their invention is also protected for 1 year from any of the following. 1, describing their invention in a printed publication. 2, making a public use of the invention. Or 3, offering the invention for sale. This is called the grace period, and it's critical to small inventors. 108 startups and small businesses wrote last year, and I quote, "U.S. patent law has long allowed inventors a 1-year grace period so that they can develop, vet, and perfect their invention, begin commercialization, advance sales, seek investors and business partners, and obtain sufficient funds to prosecute the patent application." During that grace period, many inventors learn about starting a technology-based business for the first time. They must obtain investment capital. They often have to learn from outside patent counsel at considerable expense about patenting and related deadlines and how to set up confidentiality agreements. Many startups or small businesses are in a race against insolvency during this early stage. The grace period protects them during this period, and loss of patent rights due to any activities, information leaks or inadvertent unprotected disclosures prior to filing their patent applications. S23 eliminates this grace period from offering an invention for sale or making a public use of it, leaving only a grace period from, quote, disclosure, end quote, of the invention. There are 2 problems with this. First, disclosure is not defined in the bill. This will generate litigation while the courts flesh out that term's meaning. While this plays out in the courts, there will be uncertainty about whether many inventions are patentable or not. This uncertainty will, in turn, chill investment, as venture capitalists will be reluctant to invest until they are confident that the inventor will be able to patent on their own invention. Secondly, because of this lack of definition, some patent lawyers interpret disclosure to mean a disclosure that is sufficiently detailed to enable a person of ordinary skill in the particular art to make the invented item. In practical terms, this means a patent application or a printed publication. Now, this does provide some protection to universities. It's true. They often publish about their inventions. However, it is scant protection for the small inventor. They don't publish about their inventions until they file a patent application. As the 108 small businesses put it, and I quote, "No business willingly publishes complete technical disclosures that will tip off all competitors to a company's technological direction. Confidentiality is crucial to small companies," end quote. The grace period from offering for sale or public use really is critical for their protection. Eliminating it will, in the words of these small businesses, quote, "practically gut the American 1-year grace period," end quote. The National Small Business Association wrote recently, and I quote, "The American first to invent grace period patent system has been a major mechanism for the dynamism of small business innovation. It is clear that the weak or entirely absent grace periods used in the rest of the world's first-to-file patent system throttles small business innovation and job creation, end quote. Our amendment would provide America's world-leading system. I'm also very concerned that first-to-file would proportionately disadvantage small companies and startups with limited resources. I've become convinced that this change would impede innovation and economic growth in our country, particularly harming the small, early-stage businesses that generate job growth. Obviously, the process of innovation starts with the generation of ideas. Small California companies and inventors have described to me, however, how most of these ideas ultimately do not pan out. Either testing or development proves that they're not feasible technologically, or they prove not to be viable economically. Unfortunately, first-to-file incentivizes inventors to race to the patent office to protect as many of their ideas as soon as possible, so they're not beaten to the punch by a rival. Thus, first-to-file will likely result in significant overfiling of these dead-end inventions, unnecessarily burdening both the Patent and Trademark Office and inventors. As Paul Michel, former Chief Judge of the Court of Appeals for the Federal Circuit, and Gregory Juneman, President of the International Federation of Professional and Technical Engineers, put it in a recent letter to the committee, and I quote, "As Canada recently experienced, a shift to a first-to-file system can stimulate mass filing of premature applications as inventors rush to beat the effective day or of the shift, or later filings by competitors," end quote. This presents a particular hardship for independent inventors, for startups, and for small businesses, which do not have the resources and volume to employ in-house counsel, but must instead rely on more costly outside counsel to file their patents. This added cost and time directed to filing for ideas that are not productive will drain resources away from the viable ideas that can build a patent portfolio and a business. At a time when the Patent and Trademark Office has a dramatic backlog of over 1 million patents waiting to be examined and a pendency time of some 3 years, Congress should be careful to ensure that any legislative changes will not increase patent filings that are untruthful. The counterargument is made that a small inventor could file a cheap provisional patent application, and that's sufficient protection. However, patent lawyers who work with small clients have said that they advise their clients not to treat a provisional application any less seriously than a full patent application. If there is part of an invention that's left out of the provisional application, that application will not be protected. And the parts that are included in the provisional application will also be vulnerable under an attack that the inventor failed to disclose the best mode of the invention by leaving out necessary information. The argument is made that first-to-file will establish a simple, clear priority of competing patent applications. Proponents of first-to-file argue that it will eliminate costly, burdensome proceedings to determine who actually was the first to invent, which are known as interference proceedings. However, the reality is that this is not a significant problem under our current system. There are only about 50 interference proceedings a year to resolve who made the invention first. This is out of 480,000 patent applications that are submitted each year. In other words, 0.01% of patent applications. Another problem with the bill's first-to-file system is the difficulty of proving that someone copied your invention. The bill's proponents assert that it protects against one person copying another person's invention by allowing the first inventor to prove that, and I quote, such other patent was derived from the inventor of the invention, end quote. Currently, you, as a first inventor, can prove that you were first by presenting evidence that's in your control, your own records, contemporaneously documenting the development of your invention. But to prove that somebody else's patent application came from you under the bill, was derived from you, you would have to submit documents showing this copying. Only if there was a direct relationship between the two parties will the first inventor have such documents. If there was only an indirect relationship or an intermediary, for example, the first inventor described his invention at an angel investor presentation where he didn't know the identities of many in attendance, the documents that would show derivation, which means copying, are not going to be in the first inventor's possession. They would be in the second party's possession. You would have to find out who they talked to, who they emailed with, to trace it back to your original disclosure. But the bill doesn't provide for any discovery in these derivation proceedings. So the first inventor can't prove their claim. For these reasons and many others, the first to invent system, which I believe has made our nation the leader in the world, which our amendment would preserve, is supported by numerous people and businesses around the country, including the National Small Business Association, the Coalition for Patent Fairness, that's a coalition of large high-tech companies, the Institute of Electrical and Electronics Engineers, which has 395,000 members, the International Federation of Professional and Technical Engineers, AFL-CIO, the University of California System, the University of Kentucky, Paul Michel, the former Chief Judge of the United States Court of Appeals for the Federal Circuit, which plays a critical role in hearing appeals in patent cases, and the United States Business and Industry Council, American Innovators for Patent Reform, the National Association of Patent Practitioners, Professional Inventors Alliance, USA, Connect, a trade association for small technology and life science businesses, and many small inventors, as represented, for instance, in a letter signed by 108 startups and small businesses from all over the country. Mr. President, I ask unanimous consent that a copy of this letter be placed in the record directly following my remarks.
Without objection.
Thank you. Mr. President, I don't often agree with the organization Gun Owners of America, a group that thinks the National Rifle Association is too liberal. But I do agree with them on this issue. They are part of the coalition of 23 conservative organizations that wrote to the leaders about this, arguing, and I quote, "Our competitors should have to harmonize up to our superior intellectual property regime, rather than our having to weaken our patent system and harmonize down to their levels." There are many other signatories, but I think this is really a battle between the small inventor, the beginning in the garage, the Apple computer who was nowhere, who through the first to invent system was able to create one of the greatest companies in the world. America's great strength is the cutting edge of innovation, and the first to invent system has served us well. You know, if it isn't broke, don't change it. And I don't really believe it's broke. So I'm delighted to see that my co-sponsor, the distinguished senator from California, is also on the floor on this matter. I welcome her support, and I yield the floor.